Hello, everybody, and welcome to the Heritage Foundation. My name is John Malcolm. I'm the Vice President of the Institute for Constitutional Government here today, here at Heritage. And we are here today to discuss a book, a terrific book. I've actually read it. I think it's wonderful, by my friend Ilan Wurman. His book is called A Debt Against the Living, An Introduction to Originalism. It's an excellent primer on a very important topic. We are delighted today to be co-hosting this event with our friends at the Claremont Institute. And here to lead our discussion is Ryan Williams, who is the president of the Claremont Institute, has held that august position for a couple of months now. Is that about
September
right?
1, yeah.
He has a long and distinguished career at the Claremont Institute over a 12-year period of time. Prior to being named president, he served in a number of positions at Claremont, including as the chief operating officer and director of Claremont's various prestigious fellowships, including its Publius Fellowship, Lincoln Fellowship, and its John Marshall Fellowship program. In fact, Ryan was himself, several years ago, a Publius Fellow, and Ilan was a John Marshall Fellow. Ryan is a graduate of Hillsdale College, where he studied under Claremont founder and former president Dr. Larry Arnn, who's also on the board of the Heritage Foundation. He also studied under Henry Jaffa, who was Claremont's intellectual godfather at the Claremont Graduate University, where he obtained both a master's degree and a PhD. He is a regular contributor to the Claremont Review of Books and has taught American politics and political philosophy as an adjunct professor at California State University, San Bernardino, and Cal Poly Pomona. Please join me in welcoming Ryan Williams and Ilan Wurman.
Thank you, John. I will correct you on just one point of order. I'm what they call an ancient graduate student, actually. So the PhD should get dragged across the finish line in February. So didn't want to misrepresent, but and I'm writing on William Howard Taft, actually, his Chief Justiceship. So talk to Joe Postel, who knows more about that, who's in the audience today and visiting here at Heritage. So Ilan and I have known each other for a long time. He was an undergraduate at Claremont McKenna when came out, not right when I came out to Claremont, but soon thereafter at the graduate school. Ilan's a visiting fellow, or really a fellow at Stanford. He received his undergraduate degree at Claremont McKenna College and his JD at Stanford Law School, and worked on both the Rand Paul presidential campaign and the Tom Cotton Senate campaign. Is currently an attorney here in Washington. He's the author of this wonderful little book, which if you haven't purchased it or read it, I encourage you to do so. It's a wonderful exercise in compression. It's a very nice piece of writing, and unlike most law review articles, it's not festooned with thousands of footnotes, but rather with very useful references, and it's a great guide to this topic.
I didn't include the footnotes in case I was wrong about something.
Yeah, of course.
I didn't want anyone to be able to check
it. It has endnotes, but really only dozens of them, so it's much more digestible. So thank you, Ilan, for agreeing to do this. Thank you to the Heritage Foundation for co-hosting with us. I think I want to try to do 6 things tonight in our about 40 minutes and then leave some time for Q&A. I wanted to talk just a bit about the why of the book. Why do we need another book on originalism?
We just need this one.
Yeah, just this one, right? Where your title comes from, it's of course freighted with meaning. This sort of distinction between the founders' view of constitutionalism and our current originalist debates on the right. We'll talk a little bit, I think, or I hope, about Brown v. Board and the question of race and originalism and segregation. And then I'd like to talk just a little bit about judicial supremacy, and then we can finish with everyone's favorite topic, the administrative state. So that's the plan for the next 40 minutes or so. So first of all, we'll start off with just this question of, I mean, there have been millions of footnotes and thousands, if not hundreds of thousands of law review articles on this topic, a few books. Why another one?
Well, you might be surprised that there actually wasn't a book like this. There wasn't a just short, single voice, single narrative, one volume introduction to originalism, which I discovered as a 1L at Stanford Law School. You would think that at law schools today, you would learn about constitutional interpretation as sort of its own discipline. And that would be a really good thought. but wrong for most law students. I think the sum total of classroom instruction I had on originalism and constitutional interpretation was 10 minutes, 20 minutes maybe in Con Law 1. And there are some reasons for this. I think a lot of it is just the case method itself, so you only, which lends itself to sort of this evolutionary kind of living, breathing method of interpretation. Now sometimes you'll run into a case like DC v. Heller where you have to talk about originalism, but it's very rare that you're given any substantial treatment. And so as a 1L, I had to strike it out on my own, just like most 1Ls have to do. I felt like I was intuitively this originalist thing that they were talking about for those 10 minutes, but I didn't quite know or understand it. So I looked for an introduction to originalism, and I couldn't find one. There are terrific books and articles written about originalism. And I talk about a lot of them in this book, like Randy Barnett's book, Keith Whittington's book, Jack Balkin's book, and great law review articles, but no, just sort of single narrative book that distills the findings and conclusions of 40 years of originalist scholarship. And so that's what I try to do at a higher, more broader level. In terms of a more narrow niche that this book fills, of all those millions of footnotes and pages that Ryan discussed, a lot of it focuses on this inquiry of sort of semantic meaning, philosophy of language, well, it's just how you interpret text. But I don't think that quite gets us where we need to go. I think the non-originalist argument in its best light would say that that's all beside the point, that we as non-originalists recognize that the Constitution just needs to be updated and needs to be changed. It's just, there's this thing called the original public meaning, but it's just not the law, or we don't think it should be the law. And so I think to fully defend originalism requires a defense of the founding. And that's what this book tries to do.
Yeah, in that sense, it's a Claremont, I think, after Heritage and Claremont's heart, to be sure. So let's
It's worth your money.
Yeah, that's right. Let's get into this title a little bit. I mean, this A Debt Against the Living, it's of course pulled from Madison. Why don't you just sketch that out really quickly before we get to the rest of the meat of the book?
The qualifier really quickly, doesn't describe me accurately always, but I'll do my best. So
just talk faster.
Just talk faster, guys. So Thomas Jefferson wrote a famous letter to James Madison in 1789 when he was in the throes of revolutionary Paris. And in this letter, he wrote that the earth belongs to the living. The earth belongs to the living and not to the dead. The dead have neither power nor rights over it. One generation is to another as one independent nation to another. And Jefferson's letter is well known, and it's often quoted for the proposition that we shouldn't be bound by the dead hand of the past, by the dead hand of the Constitution, that the Constitution should instead be a living, breathing document, subject to changing interpretations over time. But what's forgotten is Madison's reply. Madison wrote back, and he said something very interesting. I mean, these two men were prone to agree on almost everything in their political lives, but they disagreed on this point. And Madison said, in his letter, if the earth be the gift of nature to the living, then their title can extend to the earth in its natural state only. The improvements made by the dead, Madison said, form a debt against the living, who take the benefit of them. This debt, Madison said, cannot be otherwise discharged than by a proportionate obedience to the will of the authors of the improvement. In other words, Jefferson, yeah, you're right, the earth does belong to the living, but let's be real, only in its natural condition. The Constitution is an improvement of such importance, of such magnitude upon the natural condition of the world, that it can't but form this kind of continuing obligation against future generations that take the benefit of this debt against the living. And the only way for we the living to faithfully discharge that debt is through a kind of originalism, a proportionate obedience to the will of the authors of the improvement. So that's the set piece for the book. Who's right, Jefferson or Madison? And by my choice of title, and you're all smart crowd and can anticipate that I answer in favor of Madison and originalism in the original Constitution.
Good.
2 down, 4 to go.
So I wanted to talk a little bit about you present the case in the book that on the right and the left, there are, for our purposes here, if not generally speaking, 3 dominant positions for the legitimacy of the Constitution. And you offer the founding or the Madisonian founding view as a superior alternative. So there's the sort of libertarian approach, there's the conservative approach, and then there's the sort of living constitutionalist or progressive approach. Could you just talk about those 3, and then we can maybe interrogate the superiority of the founding.
Yeah. So, I said earlier that much of the literature focuses on this sort of semantic aspect of language, philosophy of language, but there is some literature on what makes the Constitution legitimate and binding. And it's a very interesting characteristic of this literature is that it always somehow tends to support the political predispositions of the authors. So we have some libertarian authors who say, well, for the Constitution to be legitimate, it has to protect natural rights, and properly understood, the Constitution should be interpreted with a presumption of liberty, and that's how it satisfies this condition. You have others who say, well, it's all about popular sovereignty. And then you have, the John Hart Ely's, the Jack Balkans, who say what makes the Constitution legitimate is that it creates this regime of self-government. And so we should adopt an interpretation of the Constitution that enhances sort of the democratic process or the democratic legitimacy of the Constitution. And this tends to, again, tends to lead to results that these authors prefer. But the broader point, I think, is that there's actually some element of truth in all of these views. I mean, they're all onto something. And I think the founders' view was more holistic. I think the founders recognized that all of these things had to be true, and they were often in tension with each other. And that was what made the act of founding so hard. We obviously had to create a regime of self-government, a republican regime, but also a regime that protected a large measure or a certain measure of our natural liberties. Right? Otherwise, why would we get out of this state of nature into this thing called society if it was a really raw deal? And these two things are in tension with each other. It's often popular majorities that infringe on the rights of others. And so the task of a founding, at least in a free society, the task of founding a free constitution requires a balancing act, requires balancing these two competing objectives. And the founders, I think, were remarkable, and that's not easy, And I think the founders were remarkably successful at achieving that balance.
Do you think this is an adjunct of the problem of neglecting the Declaration of Independence? Because as you point out, I mean, all three of these aspects, the protection of rights, the securing of the consent of the governed, and the sort of popular aspect of it, they're all present there in the Declaration in the first few paragraphs. So how is it that everyone misses this or wants to narrow it?
So I think people miss it because there's this very common conception, probably in the legal literature too. They don't really talk about the Declaration at all, so it's kind of hard to know, but certainly in the political theory literature, that the Constitution of 1787 was a repudiation of the principles of 1776. And so we can't really look to the Declaration to kind of inform how we think about the Constitution. I certainly think it's true that the Declaration isn't enforceable law, but it can certainly help us answer the question whether the Constitution creates this debt against the living, such that we should still be bound by its original legal content, the original public meaning. And so I think that's right. I think Martin Diamond, a good Claremontian, had the insight right.
With an asterisk. Go ahead.
Well, and he said that the Declaration of Independence was a half revolution. And this is, I think, a very important insight. It was a half revolution. It established the principles of a free government and explained why the existing government didn't meet those principles, and thus what justified our breaking away from the existing government at the time. The Constitution was the second half of that revolution. The Declaration doesn't prescribe a particular mode of government, but the Constitution does. And the Constitution, the framers in the Constitutional Convention, looked at the 11 years of history of Republican state governments and a national government, if you can call it really confederal government, the Articles of Confederation, and they saw that these free governments had certain flaws. That all forms of government have certain flaws. Republican governments have flaws and vices incident to Republican regimes that they observed over 11 years. And in the Constitution, they tried to make a frame of government that was Republican, but that remedied these vices through things like separation of powers and checks and balances, the division of federal and state power, and so on. But that's perfectly consistent with the principles of the Declaration, because the founders weren't trying to sort of undo the democratic revolution that occurred in 1776. They were trying to help it survive. which meant checking and balancing the popular will. It meant protecting some measure of natural liberty. And it is all there. And the first, I think, thing you could do to sort of recapture that is to understand that it's really this half revolution that set the principles. And the Constitution wasn't the only way we could have brought those principles to fruition. But it was certainly an ingenious way, and one that seems to have worked pretty well.
Right. But the Declaration mandates some form of Republican government, just not institutionally fixed. Is that what you mean?
Yeah. I think that's right. Yeah. Right. It says in the litany of abuses of King George III, it says he's abrogated our assemblies, he has taxed us without our consent. This implies some sort of need for Republican regime, and I think that's right. So you need the initial act of consent, you need to protect our inalienable rights, and the government has to continue operating through the Republican mechanism. Now, in the book, I obviously take that line. Among friends, I don't know how strong a line one could really take on that. After all, they accused King George III of being an unjust right, king, a tyrant, an unjust king, suggesting that there could be a just king, that protected natural rights in some respect. But then if you do look at those other things they say, they imply that it has to continue operating by Republican government.
Yeah, well, they certainly didn't mean to suggest the obvious untruth, to paraphrase Lincoln, but in a different context, that every government across the world was enjoying Republican principles, or that even every people across the world was capable of instituting a Republican government, but rather that this would be the sort of the lodestar for decent and just government for the most part, and especially in America. Right?
I think that's right.
Okay. So this...
I have nothing to add to that.
No, thanks. What do you say, I mean, you said that the Declaration, I don't want to go too far afield on this point, but I think it will lead us into the Brown v. Board discussion, so that's why I bring it up. What do you say to teachers of mine and people you know as well who say, well, look, courts don't often take up the Declaration as a matter of jurisprudential application, but it is in the U.S. Code, and it is really the only way, in any sort of institutional sense, that we can make sense of the principles versus the compromises in the Constitution. So if you stick to the four corners, this is the old critique of Robert Bork, if you stick to the four corners of the text, especially before the Civil War and before the Civil War amendments, it's really hard to tell the difference between the 3/5 clause, the fugitive slave clause, and the slave trade clauses, and other clauses in the Constitution. They're sort of on the same moral plane, with the one exception being, of course, the words slave and slavery are never mentioned in the Constitution, and I think on purpose. So what do you say to that critique or that coda?
I don't think the Declaration is in the U.S. Code, by the way. I don't know if that, I mean, the U.S. Code is actually enforceable statute law. I don't think that applies to the Declaration.
One of the organic laws of the United States, right?
It's certainly a statement of principle, right? But I don't think all the original clauses were created equal in that respect on a moral plane. And I think we can draw inspiration from the Declaration here, and there is a parallel to Brown v. Board of Education, which is that the framers of any written document or of a statement of principles of a government can make a statement of principle or a statement of meaning and can recognize at the same time that the current state of facts or the current state of the world is inconsistent with that principle. And I think the founders knew it. For the most part, the founders knew that when they wrote that all men are created equal, this does not exclude blacks. I don't think it even excludes women. But they recognized that slavery was going to continue to exist in the southern states, whether or not there's a union, and that it was better to have at least a union of states that solved a lot of other problems and over which half the country might have some control over the slavery question. But I think you can write a principle whose meaning is not informed by the limitations of the application of that principle at the current state of facts, with the current state of facts. Just because at the time there was still slavery, I don't think suggests that the meaning of these principles was that somehow they excluded black Americans. And I think the same can be said of the 14th Amendment, which is maybe where you're going next.
Yeah, no, I didn't mean to suggest as much. I just meant to outline or emphasize the
It was
importance.
a thought-provoking question, and there's no need to apologize in any respect.
That wasn't me backpedaling. That's just
Okay.
transitioning. So yeah, let's take up the question of board. I think one of the more evocative phrases at the founding of America was that slavery was the witch at the christening, in many ways of this country. I forget who said it.
Never heard that, but I like it.
It's a good one. And I think that we felt the moral and political hangover from that through to the desegregation case, Brown v. Board in 1954. And it's tied to originalism in the sense that, as you bring up in the book, the sort of original case against originalism, as it were, or one of the more powerful ones was, well, look, the originalists couldn't get Brown v. Board, the result of Brown v. Board right. Therefore, originalism just can't fly. I mean, it's sort of dead on arrival. What do you say in response to that, and how do we deal with that problem?
Maybe I'm the product of a generation of scholars who have written about Brown v. Board, but I really don't know what all the fuss is about, because I think Brown v. Board is an easy case under originalism. And there's an important lesson here, though, which is what matters is what the framers of the 14th Amendment wrote. Not how what the framers of the 14th Amendment thought what they wrote would apply in the real world, and especially not what the Democrats in Congress in the 1870s said the 14th Amendment required, or in terms of its actual application. So the Democrats in the 1870s in Congress said that this doesn't enforce this sort of social equality, it's only this legal equality, and separate but equal was still equal, and you didn't have to desegregate the schools. But how they thought that these principles and the meaning of the text applied in the world is maybe some evidence of how it would apply, of its meaning, but it's not determinative. And once it became known, and for here, I'll draw inspiration from a legendary law professor named Charles Black. And he basically said the following. Once it became known, in the 1940s, 50s, and beyond, once it became known, what everyone in the Jim Crow South knew, everyone that had advocated for the segregation laws knew, was that the purpose of the segregation laws was to keep one race of Americans in a perpetual condition of subordination and inferiority. Once that became known, that the intent wasn't separate but equal, the but equal part was not the intent. The intent was to keep them in a perpetual condition of subordination and inferiority. Once that became known, the desegregation decisions are easy. The segregation laws are obviously unconstitutional under the meaning of at least two provisions, maybe more, of the 14th Amendment, which says that no state shall abridge the privileges or immunities of citizens of the United States on the basis of things like race, and which says that no state shall deprive someone of the equal protection of the laws or deny someone the equal protection of the laws on the basis of something like race. And so we're not bound by the factual errors of the founders. We're not bound by the factual errors of the framers of the 14th Amendment. And we're certainly not bound by their motivated reasoning that led them to results that they preferred at the time. What matters is what they wrote, not how what they thought they wrote would apply.
So you would rewrite that unanimous decision, for those in the audience who don't know, was based mostly on disproven pseudo-social science, right, with black dolls and white dolls and kids' feelings about them and all this sort of stuff. Mm-hmm. Now, it was unanimous, and it was based mostly on social science. So you would rewrite it as a sort of equal protection case?
I think it's
drawing on scholarship from people like McConnell and Black and others. Yeah.
I think it's a two-page opinion. I think it's a two-pager. So yes, I'd rewrite it.
Yeah, the odd fact about the subsequent cases, which Hadley Arcus always likes to point out, he's not the only one. They say, you can't have segregated tennis courts, see Brown. It's like, what, that had to do with school children
right, and
feeling inferior, holding
exactly,
dolls of different colors. What does that have to do with tennis?
Exactly.
So it's very confusing case law.
But really, the court should have taken the dissent in Plessy versus Ferguson and adopted that sort of as the reasoning of the court, and then it would apply to all those other obvious situations, including marriage, Loving v. Virginia, another easy case.
So a case 4 years later, a frustrated court with the South dragging their feet in Cooper v. Aaron says, they quote Marshall, who said it's the province and duty of the court to say what the law is. But they use that to offer the proposition that the Constitution is what we say it is, full stop, so you must obey. And would you agree that's the foundational case for sort of modern judicial supremacy? And why is that a problem, or if it is a problem?
Yes, to the first part. And it's always awkward, right, to push back against Cooper v. Aaron because, there's this expression that bad facts make bad law, or what is it, hard cases make bad law? Hard cases?
Hard cases, bad law.
You get the gist. And we have this situation where there is this intransigent state governments in the South that refuse to enforce the desegregation decisions. And so you have a Supreme Court, and they say, well, it's only as is a correct, I think, understanding of the Constitution. The argument would go, well, the Supreme Court in Brown v. Board is only binding on the parties to that case, which when you think about it means that you just have to relitigate this 100 times or 1,000 times all across the country, even coming up to the Supreme Court 100 times or 1,000 times, right? So there's a limit to what we can do to push back against this concept of judicial supremacy. I mean, at some point, right, good faith, I do think, requires that we say, okay, this question has been settled. We can't keep litigating this between every private party, right, and the courts. Having said that, I don't think, as an originalist matter, the court had the only and final say on constitutional questions. So if we could take it outside of the desegregation decisions, where it's awkward and obviously was a good thing that I think the court was trying to enforce it, and I think good faith, again, required the South to sort of subside here. But take, for example, the Alien and Sedition Acts. You had a Congress, a president, and numerous federal courts that all said the Alien and Sedition Acts were constitutional. And Thomas Jefferson disagreed. And so he pardoned everyone who had been convicted under the Alien and Sedition Acts. Andrew Jackson vetoed the Bank of the United States on constitutional grounds, even though through a series of adjudications and deliberations in Congress, in the courts, in the states, time and again, everyone had sort of said this was constitutional. So judicial supremacy is definitely at war with that concept. Historically, Congress had sort of this first cut say at interpreting the scope of its power, and the courts, the Congress and the president could kind of get together and buck what the court was saying. But the cases I just described are the easier cases, because it's where the court says X is constitutional. Well, and another branch of government could say, well, we think X is unconstitutional, so we're not going to do it. That's easy. What happens when the court says, actually, X is unconstitutional, but Congress and the president want to do X? Dred Scott v. Sanford is the seminal example. The Missouri Compromise of 1820 had been sort of the compromise that kept the Union going. There shouldn't be expansion of slavery. Congress basically could control how slavery expanded in the territories. And in the Dred Scott case, the court basically said, actually, Congress can't prevent slavery in the territories. It said this Missouri Compromise, this agreement between Congress and the president and the states, was unconstitutional. And Lincoln said, well, we have an independent duty. The court, in that case, can bind Sanford. It could bind Dred Scott, but it can't bind anyone else. And so long as the question is still open to good faith dispute, the court shouldn't have the last word. Congress should reenact the Missouri Compromise. The president should re-sign the Missouri Compromise. This story didn't have a super happy ending for a couple years and ultimately did. But it's not clear what should be done in those cases today. If the court were to say this is unconstitutional, but there was just such dramatic will for the Congress and the president to do it, I don't know what they would do. I don't know what that would look like. But I certainly think, as an originalist matter, Congress had this sort of independent duty to interpret the Constitution, as did the president, and they often neglect that duty today.
Do you see any realm of constitutional law or institutional policy where that's more likely to happen in this current political environment, if you had to prognosticate?
I can't think of something off the top of my head where that would happen. The case, the recent case where things got close was sort of First Amendment context, religious freedom context, back when everybody believed in that kind of thing in the early 90s. You had a Supreme Court that basically said the free exercise clause did not require laws, in this case a federal law, to have an exemption for religious exercise. So if the drug laws are generally applicable, then that means Native Americans who use peyote, the drug peyote, in the exercise of their religion are still subject to the penalties of the drug laws because it's a generally applicable law. Well, Congress vigorously disagreed with this decision and enacted the Religious Freedom Restoration Act, which at the time, it might have been a different version of it, but it didn't just apply to federal government, which of course Congress could be free to enact these exemptions, but it applied to the states too. Congress tried to compel the states, through its interpretation of the First Amendment, of the Free Exercise Clause, to require these exemptions for free exercise. And the Supreme Court said, in City of Bernie, no, we said that this is not a constitutional requirement, and therefore you, Congress, do not have the power under the 14th Amendment Enforcement Clause to force the states to do this because they aren't violating the Constitution when they're not doing it. And that's like one of the key modern statements of judicial supremacy. Again, I don't know what the right answer is in that sort of situation. At the end of the day, if it kept coming to the courts and the courts kept coming to the same answer, good faith might require us to sort of just say, okay, fine, but we could sure as heck put up a struggle at first, like Congress tried before their legislation was struck down in City of Bernie. Maybe they should have tried again, get the court to think harder. But it's a hard question. It's a really hard question.
Well, and Congress is equipped to play a little more hardball, right? I mean, they can strip jurisdiction. They can abolish federal courts, not the Supreme Court, but remember the early conflict with the transition from the Federalists to the Jefferson's party. I mean, they basically abolished a circuit court, right?
Yeah.
And reinstituted circuit riding, which we should do again on horseback.
I think especially the DC circuit judges should ride
circuit.
Yeah. They can fly. That doesn't bother me. But they should see how the other half lives, I guess.
And Congress, of course, when it wants to, can disregard and lower stakes stuff, right? So the Supreme Court in the 90s, I think, right, said the legislative veto was unconstitutional, but Congress disregards that annually, right? In various contexts.
Sort of. There is no true legislative veto today. There are some informal understandings with agencies. So just some background, the legislative veto was that ordinarily when Congress passes a law, right, it has to pass the House and the Senate, and the president has to sign it. What if the president does something that Congress doesn't like? Can Congress just veto it? Well, it did, and often in immigration cases, actually, where Congress would veto the decisions of the Attorney General or the immigration judges without going through bicameralism and presentment. It could even be a committee, or one House of Congress could veto it without going through the separation of powers channels. And so the theory of INS v. Chadha was that, well, to change the execution of the law, you have to change the law. That requires you to pass a new law, which requires the House and the Senate and the President. And obviously, the president's not going to agree with you because by definition, you're trying to overturn what he's already doing. So getting rid of the legislative veto, although it was only used like 265 times-ish, something like that, in its 80-year history, I do think took a tool away from Congress. It was probably a powerful tool, a checking tool. It was probably right, the decision. There might be some creative ways we can adjust the doctrine to recover something like a legislative veto. I had this crazy idea in one of my last papers that I'm walking back from a bit now. We should certainly think creatively about ways to give Congress more power vis-a-vis the administrative state.
Yeah.
Probably launches into your next topic. Perfect.
It's like we've done this before.
Have we?
Thank you. So let's finish on the administrative state. Bannon caused a stir when he announced that, was it at CPAC, that he wanted to deconstruct the administrative state? It was like catnip for movement conservatives. A deconstruct may be a little ambitious at this point, but I do think we all need to think about, and I know you have been, and many people at Heritage and Claremont have been, about how to reconstitutionalize the administrative state. And by that I mean to reassert some control over it by the political branches who are the elected representatives of Americans. So I know you have some interesting work on this subject. It's not really in this book, but you allude to it. But
Maybe my next one.
yeah.
If we want to do this again.
Well, let's just talk about that a little bit. I think it's a good way to end, and then we can open it up for questions.
So I'm glad you mentioned the Steve Bannon deconstructing the administrative state point. So for those of us who still care about the Harvard Law Review Forward, which they do every year, reviewing sort of the Supreme Court term, a very prominent and well-respected and terrific law professor from Columbia just wrote the Harvard Law Review Forward, Jillian Metzger, and I think it's called something like 1930s Redux. I'm blanking on the title, but it's all about this anti-administrativist conspiracy that she identifies among the Federalist Society, the Heritage Action, and the Koch brothers. Oh, this is all in the Harvard Law Review.
Gotta throw them in.
Very respectable publication. No, this sort of a conspiracy on the part of the right to sort of undo the administrative state, and this is actually, I think it's a 95-page article. It's pretty comprehensive, and I think it does a good service because it sort of gives the conventional anti-administrativist, I'm not going to keep using that, but that's what she calls it, this anti-administrative state attack from formalists and conservatives over the last 30, 40 years. And I think the mostly conventional response to it. So on the one hand, we have this formalist position that argues, the textualist position, that argues that the administrative state is unconstitutional because it unlawfully combines powers that should be separate. It unlawfully combines legislative, judicial, and executive power in single hands, in the hands of bureaucrats, in the hands of, sorry about that, in the hands of agencies. In the hands of agencies, because Congress delegates in broad terms, and so then when agencies are implementing these broad statutes through rulemakings, they're actually making law. They're making policy decisions, and then they get to enforce those policies in their own tribunals, and commissions, like the FCC or the SEC, in front of their own judges. So this is the sort of the conservative criticism. The functionalist, sort of more progressive, pro-administrative law approach says, well, we just have to accept the reality that the administrative state isn't going away. We have to accept the reality of delegation. But if we really like things like the separation of powers and checks and balances, we could still have that. It would just be different checks and balances and different separation of powers. So have independent commissions that can be a check on executive power. Have the Civil Service Merit Protection Board or whatever it's called to insulate the experts and those with technical expertise, from the political decisions. And this is a way you could sort of curb executive power. All well and good, but it's just not what the Constitution says or what the Constitution requires. So those are sort of the two positions. But I think that conservatives should try something new. I think conservatives and formalists should get a bit more creative when thinking about the administrative state. And I think, and this is what I tentatively propose, and I've started to propose in some of my work. I think conservatives have to recognize that there is a difference between a combination of powers that should be separate and what I'm going to call blended powers, and what others in the literature have called blended powers. In other words, sometimes the administrative state exercises power, like when they're making a rule, implementing a law enacted by Congress, it is not clear that this is legislative power. I mean, our doctrine certainly assumes it's executive power, but the exercise of this power partakes of both executive and legislative qualities. Sometimes the exercise of power can take the shape, have qualities of judicial, legislative, and executive powers. Maybe like when the court implements the Sherman Act, which is a notoriously broad statute. It basically makes antitrust law in the particular case or controversy before it. So there's a difference between combining powers that should be separate and exercising this blended powers. I think conservatives and formalists and textualists and originalists, to the extent those things don't overlap, should recognize that a large swath of administrative power is going to be blended power. It partakes of judicial, executive, legislative qualities, or two or more of those. And the Constitution, I don't think, has a final answer on what institutional arrangements we should have vis-a-vis that kind of administrative power. But on the other hand, There are these things that are strictly and exclusively executive in nature, strictly and exclusively legislative in nature, and strictly and exclusively judicial in nature. And the conservative agenda should be to better identify what those powers are, and then to figure out how the constitutional branches of government can reassert control over those powers. So just one example from that Stanford paper I had was whatever else independent commissions do, their enforcement decisions are strictly and exclusively executive in nature. Enforcing a law wherever it's made, independent commission, a rule, an actual statute, enforcing the law against a private party when there are consequences, to private rights is strictly and exclusively executive power. So one proposal is, well, why don't we have a chief enforcement commissioner who has to sign off on every enforcement action of an independent commission, and this chief enforcement commissioner should be removable by the president. Because currently, Congress can create independent commissions, all of whose commissioners aren't removable by the president at all. In other words, why not have the president be unitary across both executive branch and independent commissions, but only with respect to the strictly and exclusively executive enforcement function? That's actually a realistic proposal that Congress could enact that doesn't even run afoul of modern doctrine. And there are other things we could talk about in terms of legislative power or judicial power, if anyone is interested in the questions, but I've gone on too long.
No, thank you. So you're basically proposing taking Humphrey's executive very seriously and breaking down the areas that aren't quasi-judicial or quasi-legislative, and carving them out for political control.
As much as in reality Humphreys overturned Myers, right, which says that the president has to have supervision and removal authority over executive branch officials, in at least taking Humphreys super seriously, it doesn't overturn Myers. And so you can be consistent with both Humphreys and Myers if you identify what are the exclusively and strictly executive functions that these independent commissions do, and somehow give the president supervision over that and removal authority over the officials responsible for that function. But you can, I guess Congress could still insulate, say, the rulemaking functions of the independent commissions. That's right.
That may be a provocative proposition in this room, so it's time to open up for questions.
And it looks like we have a microphone.
Oh, we do.
So let's say under the cruel and unusual punishment clause, many people have said that cruel and unusual was originally understood to be interpreted at the time of punishment to be what was cruel and unusual to society at that time. It creates kind of this principle that was the original understanding of it. Jack Balkin, of course, runs with this and applies it to basically the whole Constitution. But does this idea of a principle being the original understanding, is that possible? And do you see that actually having been done in the Constitution in various places?
I think at least in one place, and I think cruel and unusual would be it. So Justice Scalia often said that what's cruel and unusual is only what the founders, what would have been considered cruel and unusual in 1789. But I think this gets it wrong, right? We said earlier that what matters is what they wrote, not how what they thought they wrote would apply in the real world. And so it could be, depending on what cruel and unusual means. I think it probably means unusually cruel. But I'm not, an Eighth Amendment expert. This could change over time. I think that's right. Whether that means capital punishment is subject to that, I don't know. I think capital punishment is contemplated in other provisions of the Constitution. I don't think that means those can't be written out, right? I mean, those provisions say, if you're subject to a capital punishment, then you get X, Y, and Z protection. That doesn't mean that that precondition has to always exist. So I think Justice Scalia probably got that wrong. But I think generally he didn't commit that error, this falling into the trap of concluding that what matters is the original expected application of the provision instead of the original meaning of the provision. But I am not an expert on the Eighth Amendment, but I don't find the original expected application approach particularly convincing.
One could agree with you that Scalia got that wrong without also having to agree with the 58 case that spawned all this, right? Which the famous phrase is, the evolving standards of decency that mark the progress of a maturing society. Scalia's point was always, societies don't often mature, sometimes they rot.
Right.
So.
Right. Yeah. Whether that's the test for what has become unusually cruel, Probably not. But I don't know what the test would be exactly. John Stiniford has done some good work on this, some originalist work, and I think he comes out on this anti-Scalia sort of perspective.
I'd like to get back to Roe v. I'm sorry, to get back to Brown v. Board and Plessy versus Ferguson. My understanding is that, and I know, and I neither here nor there, I had a chance to actually ask Judge Scalia about this, which was, on the terms of originalism, they would say to Scalia, okay, Plessy versus Ferguson, both of them were decided after the 14th Amendment. So the language had not changed from Plessy versus Ferguson to Brown v. Board. And yet, Plessy versus Ferguson, looking at the Constitution, said, well, we have a separate but equal here. Brown v. Board, a unanimous decision, overturned that. They go to the originalists and say, okay, the language in the Constitution didn't change. What changed was public perceptions, cultural mores, that kind of thing. So how do you explain that? How do you answer that?
I think the short answer is that there is a difference between a higher order commitment to originalism and lower order results in particular cases. So we could all be committed to originalism and just based on our best analysis or understanding, get the lower order conclusion in a particular case wrong. And I don't think that challenges this sort of higher order commitment to originalism. So Justice Scalia, or it might have been Justice Scalia in the marriage cases, the gay marriage cases, asked, well, when did this become unconstitutional? And I think that's a harder case to answer in the gay marriage case, maybe not. But certainly the answer for Brown v. Board is that the segregation laws were always unconstitutional. And the majority in Plessy versus Ferguson simply got it wrong.
That's what he told me.
Yeah.
That's what he said to me. It had nothing to do with changing mores. Plessy versus Ferguson, they got it wrong. And the one judge who I forget his name, who was the dissenting judge.
Harlan, yeah.
Right.
But the principle of Plessy, though, was not overturned by Brown, right? In Plessy, a feeling of inferiority was said not to be true,
right.
Whereas in Brown, inferiority as such was inherently unequal.
Right.
So the principle is not overturned, right? Yeah.
Can I just quick on Brown? Have you looked at Brown in terms of the effect that it had on the teachers? Because this is something that I just learned a couple months ago, that it was a terrible decision for black teachers. Because when when Brown was instituted, black kids and white kids are being integrated into mostly white schools because they were the better schools. So black kids were going to white schools. Black teachers were not going to those schools. The white teachers were staying in the schools. So Brown in a lot of ways was a terrible decision for black teachers, especially in the South.
That is way, way, way outside my wheelhouse, and I don't want to step in anything. But that's fascinating and interesting, and definitely a line worth pursuing if no one's done it.
Yeah, and the school that in Kansas, all of the teachers that the Brown daughter, the school she was in, they all got fired. They all lost their jobs. Sorry, I didn't mean to change.
It's only 135 pages, so there was no room for that.
I
But it sounds very interesting.
I neglected you over here, sir. Back in the back.
I have a question about a recent court case. It's now been appealed, Smith against Obama. You know the case I'm referring to.
Remind me?
This is the one in which an Army captain, I think, was deployed to the Gulf and filed a case based on Little against Bareem, questioning whether his orders were legal. And the Department of Justice, in responding to this case, said the courts are not qualified, this is a political decision, and so on. Now, the courts did rule. Chief Justice Marshall had no inhibitions about ruling in the case of Little against Bareem, and it seems to me, if you're not supposed to obey an illegal order, who's supposed to tell you whether the order is illegal if not the courts? And if you go to the courts and you're told, we're not going to make a decision, you're hung out to dry. I mean, I just don't know. But I'm asking this in terms of what seems to me the repudiation of Little against Bareem, which goes back to the original founding era. And you're nodding, but I'm not getting it. Yeah. Huh.
There was no question mark, though. So the political question doctrine, though, did, I think, originate with John Marshall. And so I think the court has certainly run amok with certain doctrines, and there's this view among conservatives especially that the court often abdicates its responsibility to decide important cases, not just there, but in other modern hot-button cases, or if it doesn't want to decide them, it's just going to presume them to be constitutional because it doesn't want to avoid them. And I think that's probably right, that the court, in some respects, has become cautious when it comes to political questions and interpreting that broadly. But maybe, and I think this is right, maybe that's a response to this trend that we talked about earlier, of this move from judicial review to judicial supremacy. I mean, it's very easy to forget about the political question doctrine and other sorts of judicial deference doctrines and abstention doctrines when you only bind the parties in political cases. It gets very hard to wade into hot-button political issues. A political question is a bit different meaning. It's not just political in the sense of it's interesting politically. I mean, it's sort of incidental or part and parcel of the political functions, the discretionary functions of the political branches. So I don't have a specific feeling about that case, but I suspect, and just based on bits and pieces that I've heard and read, that these sorts of doctrines result from the court's move to judicial supremacy, and maybe this is a way to check that move a bit. But other than that, I have no sense of the merits of that case.
Yes, ma'am.
Ilan, thank you for your informative talk, and congratulations on your new book.
Thanks for coming.
Yeah. So I think, although I think I agree with you, I'm going to play a little bit of the devil's advocate here. Getting back to your distinction between the original application of the text versus the original text, how the founders would have thought it applied versus what the text itself says. How do you take the approach that you do, which is to go with the text, without sort of slipping into the Jack Balkin framework originalism kind of approach, which says, oh, we can extract this principle from the text and apply it, in the modern context. We're talking about the cruel and unusual punishment or equal protection, et cetera.
So I think the answer, again, is that at a high order, at a higher order level of the task, what we're actually doing here, I don't think Jack Balkin is wrong about a lot of what he says, right? That the text is divided into specific commands, right? But then it also has standards, slightly higher order level of generality, and principles, higher order level of generality. The question is ascertaining the meaning of unreasonable searches and seizures. So if it means the government can't invade your property rights without a warrant, that applies to a GPS device put on a car. I think that's clearly right. The problem becomes when scholars or authors then just get the lower order questions wrong, where they say, well, under this view, therefore, equal protection and due process are X principle, which leads to Y result, when in reality, it's probably a narrower principle that leads to a much narrower sort of circumscribed range of plausible originalist results. But at a higher order level of what the task of originalism is, I don't think Jack's wrong. And I certainly think he's consistent with what many modern originalists, conservative originalists would say. They would just say that he gets the application wrong. The first reviewer of my book did accuse me of being a living constitutionalist, which stung a little, because I do think there's a difference. But there's also sub-truth to the claim in the sense that I think originalism properly understood is more capacious than many originalists often take, especially the older originalists. There's too much fixation on one right answer, and I think sometimes the answer isn't fully clear, but might lead to a range of plausible originalist answers. Still enough to discount the prevailing non-originalist interpretations, but I think originalism is more capacious. And at the end of the day, that's why our Constitution has been so successful and so enduring, because, again, the founders didn't write. You have the freedom to write with your quill and parchment. They didn't say you have a right to be safe in your carriages They said they wrote higher order sort of levels of standards and principles that could adapt to future factual circumstances. So I'd like to disagree with Jack. I do on a lot of, again, application, but he's probably right at that level.
Finish in the middle. We have time for one more.
How would you assess the impact or the legacy of originalism? Not to suggest that, it's still a relatively new intellectual phenomenon, really only about 30 years old, but it seems like in terms of academic scholarship, originalism has really revolutionized the landscape. And yet, our Constitution seems to still be distorted by courts and by positive law. So there's a lot to sort of chalk up on both sides of the ledger. How, all things considered, would you assess what originalism has accomplished and what might it still accomplish?
Well, it will accomplish a lot more as soon as everyone gets this book for their friends for the holidays. So the first thing I'll say is I'll push back a bit on one of the premises, which is originalism is only about 30 years old. I think it's true. I mean, the term originated almost 40 years ago, not quite 4 years ago. Probably the movement's a bit older than that. But it's a little funny to say that originalism is a new thing, because it's just how everyone did law back in the 1700s and the 1800s for the most part, right, until maybe the late 1800s. It's just how people did law. Lawyers, judges, members of Congress when interpreting the Constitution. The question was, how do we get at the intent of the lawgiver? And the way we do that is we look at the external signs that they use to express that intent. And those external signs generally have an objective, ascertainable meaning that you can then put against the background of the purposes for which they were legislating and against the existing corpus juris to see how it fits in the rest of the law. That's just how they did it. David Curry has this magisterial study of the Constitution, of congressional interpretation of the Constitution in the first 75 years of the Republic. If you get to volume 3, the Jacksonians, he said everyone was an originalist. Madison's notes just actually were published not too recently when the Jacksonians took power. And he said everyone was an originalist in Congress when they tried to figure out what their power was. So there was a change, there was an interruption that occurred largely because of the legal realist movement, which went sort of hand in hand with the progressive movement in the early 20th century, which basically stood for the proposition that judges don't really discern law. They just make it up as they go along. The hard version, the severe version of this is a judge will decide a case not based on the law, but rather what they had for breakfast that day. I mean, that's sort of a caricature of it, but in some sense it's true. And the legal realists had important insights, right? I mean, formalism isn't be all end all. If it turns out that judges are really deciding cases or reaching certain results because there's something else going on, some predisposition that they have or some desired result that they have, that's good to know. That's good to know, and we should make sure that judges are following the law and not those sort of predispositions. But originalism is a much older thing. Final thought in terms of what it's accomplished, in terms of originalism is accomplished in terms of recovering sort of this way of doing law. Justice Kagan says, we're all originalists now. Is that right? I mean, at least a little bit, right? At least a little bit. I mean, there's this higher order, again, level at which we are all originalists now. D.C. v. Heller, 5-4 decision, originalism on both sides. You look at as a fish a tangible object case. Why am I blanking on the name of the case? Yates v. United States. Textualists on both sides. Fish isn't tangible. I guess that's right. I mean, I don't know if that conclusion was right in the context, right? But we're all textualists now. We're all originalists now. And even if it turns out that different parties, conservatives, libertarians, liberals, use originalism to achieve their desired results in particular litigation or particular cases, at least we're having the right debate. And if we're all on the same debate, having the same debate, that makes it a lot easier to refute incorrect or erroneous positions. You know, how do you refute a Dworkinian judge? You don't. I mean, I guess you could a little bit, but it's really hard. So they've, and Justice Kagan, final thought, attributed that success to Justice Scalia.
So you'd say we're a far cry from the Warren Court era in terms of how judges, even Supreme Court justices, approach their reasoning. And
I have better days and worse days in terms of how I feel about
sure.
this, but I think generally that's true.
on that happy note, thank you to John Malcolm and the Heritage Foundation, and thanks, Ilan, and please join me in thanking.
Thank you. There's a reception, I think, right outside. Thank you all.
Reception to follow, and thank you all for coming.
Only 135 pages. Only $20 on Amazon. I think it's cheaper here.